We are halfway through the course. We've got contract formation, contract formalization. We're now on contract terms. There's two kinds of terms, express and implied. We've done express. What do the words mean given a context and community? Then we've turned to implied. What are the gap fillers that courts and the Uniform Commercial Code and the common law add to a contract that aren't there? And our key examples of that on the common law side is the implied covenant of good faith and fair dealing. It is an implied term. It is not written anywhere in the contract. It doesn't have to be. It gets added to every contract that there is a duty of good faith in the enforcement and execution of the contract. Similarly, then under the Uniform Commercial Code, we are seeing three promises, well, really two implied promises and then one third kind of hybrid promise that's set out as a matter of buying things you can move. So think the kinds of promises you would want to have as the buyer of something from Amazon. And that is our 313 express warranties, 314 implied warranty of merchantability, and 315 implied warranty of a fitness for a particular purpose. The only reason that we even add 313 express warranties as part of our implied warranties section is because sometimes these express warranties are things people orally say during the negotiation process. And what we have to understand is that they do become part of the contract and they are enforceable as long as you can get evidence of them into court past the parole evidence rule, which you very well may not be able to. But that's what I need you to understand about why those express warranties are expressed. They were just usually stated or somehow don't make it into the text of the contract, and that's the tension we've got with 2313. I'll give you a real key example from the bar exam, from my exam. If you go look at the kinds of things that are express warranties under 2313, they don't just include things that the salesperson says. Here's some that'll catch you on the bar. The picture on Amazon, right, is an express warranty that the goods will conform to what it looks like in the picture. A sample is an express warranty that the goods as provided will be the same as the sample. There are other kinds of express warranties we dealt with then in Carpenter where we said, look, the basic test for a 2313 express warranty is this, that someone has made a sufficiently definite statement about the product and that was part of the basis of the bargain for the other person. So, you'll get tested on the basis of the bargain part of it by saying, you go in and you're inspecting my truck. And I say, my truck is amazing. It gets 70 miles a gallon. But the thing is, you've brought your Aunt Marge with you. And your Aunt Marge knows everything about Ford F-150s that anyone has ever known. And your Aunt Marge says, no, actually, this thing is an overgrown paperweight. It's simply not going to move. And you buy it anyway. My statements are probably not part of the basis of the bargain because you had an expert there that was able to tell you otherwise. So that's a test on the basis of the bargain portion of 2313. But that's more or less what you're looking for. You're looking for a sufficiently definite statement by someone that can include a picture, it can include a sample, or it can include things salespeople say, things Freds say. And then the question is, can you get that incorporated? Answer, it is often part of the deal, but you may have trouble proving it past the parole evidence rule. Chris, I saw a hand.
Yeah, so talking about warranties. So in 313, in the very last part in section 2, it says that the seller doesn't have to expressly say it's a warranty or something. There are actions or words can
yes.
imply that.
Yes.
But it also says that puffery or whatever word you used last time.
Yep.
That doesn't count. So
yep.
Where's that line exactly? I remember you used the candle analogy, but I don't remember
Sure, yeah. So where's that line? What am I going to say?
Who's paying you?
Well, true. And so what happens to that line as who's paying me shifts? That is not a line, ladies and gentlemen. That's a lever, is what that is. That's not a line. That's a lever. I don't know. Who do you want to win this, and where do you want me to push that line? Because I think you can see how you can push it in either way. I will do things like write an exam question in which someone comes in and says, hey, I need a car that gets good gas mileage. And the salesperson gestures to a 1989 Ford F-150. which by the way does not get good gas mileage, right? And so like that gesture combined with the sufficient definiteness of the consumer's statement may really give you a fact pattern where what I need you to see as attorneys, because ChatGPT won't, what I need you to do is see as attorneys that fact pattern quite likely lets you bring a cause of action under 2313. And you need that because, as we're about to see in the cases today, people try to disclaim these warranties left and right, and usually their disclaimers work because all they have to do is put the words "as is" or "with all faults" into their contract, and all these warranties go away. Except 2313 warranties don't. And so often this is a place where you can really find a cause of action that's hidden under the surface of the law. All right, that's our full discussion of implied terms up through and including, and I know this is a little confusing, express warranties under the Uniform Commercial Code. We're now going to move into the true implied warranties. There are 3, but we're only going to discuss 2 of them. There are 2 implied warranties that we'll go over for movement of goods, and they're the big ones. All right. Further questions about where we are? Yeah.
So you can't disclaim a 313 warranty, but you can use the parole evidence rule to keep it out of court.
That is correct. For example, imagine under the parole evidence rule, again, I'm doing huge simplification. But the parole evidence rule basically says if we have a final written agreement, you can't bring in evidence outside that agreement to contradict its terms. Now, at this point, you should go contradict, asterisk, asterisk, asterisk. You're channeling Judge Traynor, right? You're like, I can make anything contradict. I can make anything not contradict. I am going to get paid today as a lawyer, right? Like you can do that. But let's just gather the basic idea of you can't contradict the term. Well, what then if you're worried about someone saying, hey, Fred's been making representations about these cars, and I believed Fred such that this is part of the basis of the bargain? One nice thing to do if you want to keep that out of court is make them say the opposite in the contract. So, seller has made and buyer has relied upon no material statements of fact regarding this product other than the statements made within the 4 corners of this document. Do you see what that does? It doesn't make it untrue. That's not a disclaimer. That's not saying I make a promise and I take it away. It's just saying evidence that the seller made an express warranty in this oral fashion, right? That the seller made an oral express warranty, and evidence that the buyer made that part of the basis of the bargain. All of that evidence directly contradicts that particular clause. So it's kind of like you can do an upgraded integration clause that really serves to hedge out these 2313 warranties. Have to say though, if you get past the parole evidence rule in some other way, like the judicial admissions exception, right? Which can be really dangerous. Remember, all they got to say is, oh yeah, we had a deal, but the terms of the deal were just different from the terms that you're talking about in court, Your Honor. You just said we had a deal. I am now past the parole evidence rule, ladies and gentlemen, and this stuff is coming in, right? So if they screw up, or if there's some other way that you're able to get past the parole evidence rule, then you do need to be aware that that underlying oral statement about the quality of the product may well, those oral words may get added to the written words of the contract. That make sense? Sweet. Any more before we move on? 314, yeah. Oh. Sure. There's just a common way that they put that on the bar exam to sort of test the basis of the bargain component. And now that I've told you about the basis of the bargain component, I have to give you one further idea because otherwise people run into it and they're like, ah! So the basis of the bargain component is the idea that, like, if you make an express warranty and I'm like, yeah, but I just don't believe you. Like I'm drawing on stuff from somewhere else. Then maybe that doesn't count as an express warranty. The problem with that is, practically speaking, then some attorney had the brilliant idea, wait a minute, most warranties, think about Easterbrook, right? Think about Hill versus Gateway. Most warranties, we don't even see until we've had the computer for 9 months and now the damn speaker's not working and we go and check the warranty, right? So it's hard to say that, like, at the time of the purchase, the warranty was the basis of the bargain. And so you get like courts then having to manipulate that rule about basis of the bargain to say things like all written express warranties are part of the basis of the bargain. right? But at least for oral express warranties, there's this argument that if you weren't relying on that person at all, and we'll see this argument again with 2.3.15 when we get to it. So it's a good prong to use because it does double duty. It's the basis of the bargain component of 2.3.13, and it's the reliance component of 2.3.15. In both of them, look out for fact patterns in which you think this person's got their own expertise. They weren't actually relying on the statements being made. Okay, good one. All right, anything else, y'all? Sweet. Then let's get into 2.3.14, which is the most commonly tested, and the most strictly used and common implied warranty. And in fact, it is the most common implied term that you're ever going to hear about. This one is right up there with the implied covenant of good faith and fair dealing, which applies to everything. And so that one's a monster. This is diet monster. This is a pretty damn big deal. So I'm just going to tell you real briefly what's going on with 2.3.14, and then we'll jump into Vlasis and Montgomery. All right, here's the deal with 2.3.14. It is an implied term of every contract for the sale of goods made by, and here's where I need you to pay attention, made by a merchant in goods of that kind. Not just a merchant as defined by 2.104. What's a merchant? Under 2.104? Yeah, someone who knows the reference 2.104, right? Someone who knows 1.104. Someone who knows the definition of merchant is great because they've got specialized knowledge of commercial law. But also a person could be considered a merchant if they are an expert in that industry, right? If they're really good. Your Aunt Marge, right, who came along and helped you with F-150s, in the pickup truck trade, she's going to be an expert, right? So that would be a merchant. Merchants are people who've got specialized knowledge either of law or of the industry. A merchant in goods of that kind is not that. A merchant in goods of that kind is a computer salesman selling a computer. That's a merchant in goods of that kind. The way they test it on the bar exam and on my exam is often with lawyers because we are preoccupied with our own states of being. And so it'll be something like, Josh Fairfield, starting his own business as Fairfield Consulting Limited, goes and buys a couple of desks, one for his home office and one for his recently vacated third daughter Hannah's bedroom, in which he needs to be able to relax and play Kingdom Come Deliverance 2, which I still have not gotten more than 15 minutes into and I've heard is really, really good. And what I need you to know about that fact pattern is what game am I playing there? He buys 2 desks. Yeah, whether it's for the business, right? And if I sell, so I used to give a question, actually a legit question, where I said, let's say I sell a desk that's been in my office. Well, that's not me acting as a merchant in goods of that kind. That's just me acting maybe, like at best, as a merchant, but even then, not in my mercantile capacity. I'm just doing that as a private entity. But where I used to teach at Indiana University, there was such a huge campus. They actually had so many desks and chairs and stuff out of the various rooms and offices, they built a store, right? And you would go into like the university used furniture store. And at that point, they're a merchant in goods of that kind. They are routinely selling out of inventory this kind of good. So that's the first thing for the 2.3.14 implied warranty of merchantability, which is the big one. The first thing is that it is automatically made by anyone who is a merchant in goods of that kind. And it's automatically made when there is a sale for merchants in goods of that kind. And the elements of it are simply this, that it is, the thing that you are selling is average for what it is. And if you think that gives you slip and that that's another lever that I'm handing to you, you'd be right. It's average for what it is. Let's try this. Let's say I was a car dealer. Does my Ford F-150 violate the warranty of merchantability? Clearly, Nate, because it doesn't go. Can anyone get me out from under it and say clearly not? Scott.
That's typical of the age of the car and the amount of use it's endured.
Right, and it's typical for what? I want you to see the very subtle moves here. Typical for what?
This type of vehicle?
For this type of vehicle?
For a vehicle of this age.
For a vehicle of this age, under these conditions. Do you see what's happening? It's our Oahu Nation move again. All we're doing is spreading it, getting it out as far as we want it to make sure that this is of average quality for the thing. And so what's the average thing we're aiming at if we want to say, it doesn't run? What do you mean it satisfies the implied warranty of merchantability? What's your average thing you're paying attention to? Most cars sold by this person, right? And then you're going to constrain that universe down if you want to say, no, but it's average for a paperweight, which is what it's being openly sold as. And so that's an average paperweight. What's the answer? Who's paying me? You guys get the point. This is a lever, not an answer. All right? Cool. Finally, with the implied warranty of merchantability come very specific rules for disclaiming it. We will get to those under 2316. Those are really, unfortunately, the implied warranty of merchantability is quite easy to disclaim. And so in almost all cases, it's gone unless a federal law applies. And we will take a look at that federal law next. All right. Any questions about just the basics of 2314? It's a representation by merchants who sell things like this, that the thing they sold is of fair average quality for the kind of thing that they're selling. All right. Cool. Then let's get into the cases. And let's see. Marlene, if you wouldn't mind setting up Vlas's for me, please.
Glasses ordered 2,000 hybrid chicks from this catalog, and they were noted for their excellent egg production. He received the chicks and placed them in a new sanitized coop that he made, and took a lot of precautions to get them like a clean and safe place. Within a few weeks of their delivery, the chicks began showing signs of a sickness. And then months later, they were formally diagnosed with a form of bird cancer that can be transmitted through their eggs. And then the disease eventually affected the entire flock, killing most of the chicks and caused no egg production.
Got it. Okay. And we're going to walk through the black letter law of 2314 here in a minute. I'd like to just start by asking you a completely unfair question, not about the rudder, not about the black letter law, but about the wind under the court's wings. What single fact sold this case?
Sorry, what?
And you can call in co-counsel if you'd like, Bailey. He slept with the chicks! Oh my God! Right? This is called getting homered. At this point, the defendant's like, oh my, right? Just going, gone. That is out of here. That has nothing to do with the case. Nothing. But I can tell you already, because the court mentioned that he slept with the chicks, I can tell you the outcome of the case. I don't even have to read the damn thing. All right? This is probably our single best example, put it in the silo, of talking about the need to plead your facts in a way that presents your case in the most attractive framework for winning the case. And that may or that may not have anything to do with the legal theory. It may just mean that you are giving the court wind under their wings and giving them every excuse to want to drop the hammer in your direction. All right? Cool. Now let's go through the black letter law. Are we under the common law or Uniform Commercial Code? We're under the Uniform Commercial Code. I'll be pedantic. Why are we under the Uniform Commercial Code? Because animals, and sometimes people miss this because they think we're talking only about widgets. But remember, agricultural products, animals, these all count as movable goods, and so they are goods under the Uniform Commercial Code. Fine. Now let's just go through 2314 and deal with this in pretty straightforward order. Does this qualify for 2314?
Yeah, the seller is liable for the breach of merchantability, even though there was the undetectable defect.
Right, and that's the key part of the case. And what I like there is you're raising the actual issue of the case. Let's set that aside for a second. The detectability, you're right, it's where we're going, right? But let's just set that aside as kind of advanced work, and let's move through 2314. First of all, is Montgomery Ward, do they make an implied warranty of merchantability? Right? This guy buys chicks out of a catalog. They show up. This is pre-Easterbrook. There's not even necessarily a contract that comes along with it, right? This is the way the Uniform Commercial Code works. It's quicker, dirtier, easier, more seductive. You just simply buy a gallon of milk. There was a contract. Did we exchange paper? We did not. Same deal here. The guy just orders chicks. They show up. There's a problem with them, right? Is Montgomery Ward going to be making this implied warranty that sort of comes out of nowhere with everything that they sell out of their catalog? Yeah, obviously. Why?
Because he is a merchant of that kind.
Yeah, Montgomery Ward, by the way, was like an old catalog company, right? You used to, actually, I think, maybe I'm making this up, and if I am, I apologize for the damage I'm doing to American history. I think there was a period of time where people were able to like mail order buy houses, and a lot of them got set up across the Midwest from that, right? So we're talking, this was the internet. These catalog companies were the way that people got things magically sent to them by huge factories, you know, to the center of the country. So yeah, no surprise there. They're the most merchants and goods of that kind that have ever merchants and good of that kinded, right? They're a catalog company that says, these are the kinds of things we sell, and then they did, right? It doesn't get any more merchants and goods of that kind than that. All right, fair enough. I do want to point out one other thing that's going to come up in Gilbert, which is going to be a hard case for y'all to understand, and we're really going to need to break it down. There's one of the things that's very interesting here. I just want you to note right now that he ordered directly from them and they shipped directly to him. And that is why that's why there's not a problem with using 2314. Who do you sue? I know this is a pedantic question because we've just already answered it. But who do you sue when you sue under 2314? You sue the seller. The problem was, though, that we had a transition in our economy in the middle of all of this, right? If I buy a Honda with a 90,000 mile powertrain warranty or something like that, right? Why is that not like this case?
Because you have a manufacturer and a seller.
Because you have a manufacturer and a seller. And that difference between the manufacturer, who you can clearly sue here under 2314 because you're suing the seller, and the seller and the manufacturer are the same. In most portions of a modern economy, the seller and the manufacturer just simply aren't the same. And so we're going to have to deal with that because that turns out to be a big problem in the next case. That is a problem called privity of contract. Contract law generally binds only those parties who have signed the contract. And in some of these cases, there's going to be a block in some jurisdictions, not in all jurisdictions, we'll talk about that. But in some jurisdictions, there's going to be a block against suing the manufacturer on a warranty that was an implied warranty that was made by the seller. Can you see those are two different contracts? The seller sold it to you, and when the seller sold it to you, they're the ones that make this implied warranty. They're the ones that we have this implied term. The manufacturer, theoretically, didn't make that implied term at all, or if they did, they made it as part of their own representations. And so we have to solve this problem of what is called vertical privity of contract. In an industrialized commercial economy, often the person who's making certain contractual promises is not the same as the person who is selling you that thing. And those old rules around virtual privity of contract start to run into trouble. Now, we tried to update all this. We kind of got halfway to updating this before we lost the ability to pass new laws as a country. And so what we did was we started with saying, hey, in many circumstances, you can sue the manufacturer. That's maybe not my phone. Okay. I hear that. For me too, and now I did. So the idea is that in many modern frameworks, it makes sense. The manufacturer made that 90,000 mile powertrain warranty. You can sue the manufacturer for that 90,000 mile powertrain warranty. That seems perfectly straightforward in modern frameworks. But I have to say that the Uniform Commercial Code was written at a time when those two frameworks were in transition. And so there still are some problems of vertical privity. It's one of the hardest things to get your head around. We will see it in Gilbert. I'll try to give you an account of what's going on there. It'll require a little bit of advanced work. But I want you to see right now the problem we're running into is a problem of a cracking economy. The economy is changing from mom and pop stores who are selling people things directly, and so they're the ones that should get sued if something goes wrong with a product, to we're all buying from like massive wholesalers who don't even think of themselves as merchants. Like if you can say nothing more deadly than, hey, Amazon, you look a lot like a merchant in goods of that kind. You can say nothing more deadly to them. They are terrified by that statement. They will fight you to the bitter end. No, we're just a marketplace. They want out of that loop so bad, right? In an economy like Amazon's, this old thing where you sued the seller doesn't work well. And so that's one of the advanced things we'll see when we get to federal law that tried to solve the problem, got about halfway there before it ran into Easterbrook. And we'll talk about that in a minute. All right. One last point then. What's this about detectability?
It's not relevant to the warranty. It's mostly about the quality of the goods and the seller's knowledge.
Right?
It's not relevant.
It's not relevant. Now, have y'all had products liability yet in torts? Okay. If I make a chainsaw and it turns out to malfunction, and I can show the court I took every precaution. I did all of the best industry practices, and I checked all of the boxes to make sure that my chainsaws are safe. It's just sometimes chainsaws malfunction, and I've literally done everything I can. Do you think as a matter of tort law, do you win or lose?
You'd lose still.
Because?
It's strict liability, so even without
It's
fault, like they're liable if their products cause damage.
right, so that's the standard of strict liability, but notice I added to strict liability. So you're in the right area, you're talking about the right thing. In strict liability, we're not asking were you negligent, we're simply saying a different test, which is would the precaution you take have prevented more damage than it cost or not? And that's the standard that you'll get to on strict liability. What that means is you can get a defense even in strict liability. If you say, look, I did everything, not just I wasn't negligent, not just I checked, I did every precaution that the industry can think of. I followed all best practices and something still happened. What I need you to know is that's still, although I wanted you to see products liability as the standard that we're working from here, that's still a defense to say I did absolutely everything that could be done. That's very different from saying I did everything that satisfied my duty of care under negligence. What I need you to see here is that this is something even above strict liability, right? Let's try it. Let's say I sell you a pair of jeans, and the relevant moment for testing the implied warranty is when I sell it to you. So I sell you a pair of jeans, and here's the thing, I have the best inspection processes in the world. All right? But a malicious customer comes in and puts a rusty tack in the jeans while they're on the shop floor. And then I sell you those jeans and you sit down and you're like, that hurts. Ow. First of all, does that violate the implied warranty of merchantability?
You say yes because you'd expect the jeans not to have a tag.
Yeah, because they are not of fair average quality, because I don't care where you put this, like vintage jeans, like mass market jeans, apparently skinny jeans, no longer a thing. All of that stuff, we can play this growing and shrinking game all we want. Nobody thinks rusty tacks in a pair of jeans doesn't violate that implied warranty of merchantability. And it doesn't help at all to say I had all of the very best practices in the world. Even if I was able to defend against a products liability suit, what I need you to see is that contracts are beyond even products liability. Contracts are beyond even strict liability. Contracts are what I will term for this class absolute liability. There is only one question in determining liability under a contract. What is it?
Did you breach it?
Did you breach it? I don't care what precautions you took to not breach it. I don't care how hard you worked. I don't care how expensive a precaution stopping the breach might be. I don't care. You made a contractual promise. You did not follow through on it. you have breached the contract. What I need you to see is that these warranty claims are one of these places where the walls of this classroom start to get thin. They start to get thin here between this classroom and your torts class. These warranties can really start feeling like torts. Your toaster explodes. Clearly products liability, but also check it for 2314 implied warranty of merchantability. Check your torts action, check your contracts action. Look at both. They have different standards, and the main one that I need you to know that is the point of Vlasis is not only was Montgomery a merchant in goods of that kind, not only were the checks goods, not only were the checks obviously goods that had a defect with them that made them not of fair average quality, right? But also the fact that that defect was completely undetectable and that Montgomery Ward was absolutely innocent has nothing to do with the case. That these are simply rules of contractual liability. We do not care what precautions you could have taken to avoid breaching the contract. We just care that you breached the contract. Any further questions on 2314? Yeah.
What if there was a recall? Then is it still a breach if they send you a recall on a product?
We will get to that. That gets to remedies. Here's the deal. When you detect a flaw, you have to tell the other side under the UCC as soon as possible that you have a cause of action. That's under a very specific provision under the Uniform Commercial Code. If you don't, right, it's under the common law, and that's just, there's a period of time, the statute of limitations, in which you can bring the cause of action. But you have to tell them right away, and the reason that you have to tell them right away, among other things, is to give them an opportunity, if they can, to do what is called cure. If they can fix it, they can get out from underneath the breach of contract by curing the defect. It's a dance. You find the defect, you tell them about it, they offer you cure. Oftentimes the cure doesn't work. That's what we saw in Gilbert versus Monaco. Think about buying a car. You buy a car, it's a lemon, you bring it back to the dealer, they try to fix it, it's still a lemon, you bring it back to the dealer, they try to fix it. That's that dance of cure, of breach and cure and breach and cure. And then at some point you're like, okay, as of the third visit, you're just done, like, and there are rules for that, saying it's gone too far. They don't no longer have this opportunity to cure. That's now ripened into full-on breach of contract. But we'll get to that when we get to remedies. It's a really great question. The answer is cure. All right, cool. Any further questions about 2314? Like, for example, if they'd have shipped him, and they should have shipped him, a number of chicks that didn't have the disease as a cure, there's every chance that they could have gotten out of this lawsuit. But they didn't do that. Okay, yeah.
You said we're dealing with a cracking economy here, shifting from direct privity to like the dealer economy?
Yeah, to manufacturers being the ones who are making most contractual promises in a mass marketplace.
Is that cozy core to industrial or industrial to something?
That is cozy core to industrial,
Okay.
is that shift. And you're right then to be looking for the further mutations as we hit the information and data economies, because it will further mutate, as we will talk about.
Especially in like electronics, like a lot of the stuff now comes with like a activate your warranty thing.
Yep.
If that like actually came to court, would the courts even entertain like not activating your warranty?
Yes.
Or they would?
They would. They would. Courts, I can't tell you how much courts love to enforce contracts exactly as they're written.
Why is the question in Vlasis not a mutual mistake in fact? And like if the industry practice was the buyer takes the risk of having a poor check, then, you know, the liability was on the buyer?
Yeah. Great question. That also goes to remedies. I'm going to answer, but it's going to be tight. So the question is risk of loss. Who in a transaction bears the risk of loss for the goods? And that risk of loss analysis has very specific rules that we will look at in later cases, although we will see these risk of loss rules in the next case. The way it works for risk of loss is, let's say somebody's shipping you a glass vase and it gets smashed in transit. The problem is, are you on the hook or are they on the hook? Now, I'm here to tell you, in many cases, you're on the hook. They're only liable until they put the goods in the hands of the carrier. But that's a whole discussion. And there's another rule that says, although that is true, that although the goods pass, the risk of loss passes when generally, this is the background rule, there are many other rules, we will get to them, but generally risk of loss passes when the manufacturer places this into the stream of commerce by handing it to the carrier. Although that's the case, there is another rule that says if the goods are not conforming at the time that they pass, then the risk of loss stays with the seller and never does. And so that when the buyer, if the buyer succeeds in doing what's called rejecting the goods or revoking their acceptance of the goods, what that does is that pushes the risk of loss back onto the seller the whole time. Even though risk of loss looked like it passed, because of the breach of contract at the point where the goods were handed over, risk of loss doesn't pass and remains on the seller.
No matter who's aware of it.
No matter who's aware of it, doesn't matter at all. Does matter whether you can prove it in court,
Right. Yeah.
but doesn't matter who's aware of it. Okay? Love that question. All right. Anything else, y'all? Yep.
So I just remembered that this case also specifically mentioned a implied warranty for fitness of a particular purpose.
We will get there,
Okay, so I was way off.
which is our next case. We are done with 2314. We are moving to 2315, which is implied warranty of fitness for a particular purpose. And let's see. Jewel, would you mind setting up Massey Ferguson for me, please?
So Utley purchased a combine from a farm equipment dealer. It was manufactured by Massey Ferguson. At the sale, there was a Massey factory employee, and the contract for the sale form was provided by Massey.
Yep.
So the back of the contract stated that no implied warranties were created, and it also said that Utley agreed not to raise any defense he might have raised against the seller, against the assignee of the
Yes.
contract.
Mm-hmm.
It was assigned to Massey, and then when Utley stopped making payments, Massey sued him to recover. And Utley raised the defense on a breach of implied warranty of fitness.
And that is 2315, implied warranty of fitness for a particular purpose. Exactly right.
The jury originally found in favor of Utley, and it was dismissed, and then Massey appealed.
Okay, fantastic, fantastic. Let's get the black letter law nailed down, and then we'll have some advanced questions. So common law or UCC, where are we?
UCC,
We're under the Uniform Commercial Code. Why are we under the Uniform Commercial Code?
because he's purchasing a good.
Because these tractor parts, because these combine parts are movable, and so that counts as sale of goods. Great. This is a little bit obscured by the case, and they don't make it clear. What implied warranty are we arguing about here? 13, 14, or 15? 2315, implied warranty of fitness for a particular purpose. I will have a very unfair question about that in a minute, but for now, that's the one we're looking at. We're looking at 2315. And did you notice the other statute that we're paying attention to? What did the court say about this? The fact that on the back it said, we make no implied warranties. What did the court say about that? It talked about 2316. So this case is this case is very important, and it applies not just to 2315, implied warranty of fitness for a particular purpose, but we're also talking about the disclaimers that are going to knock out 2314, implied warranty of merchantability. And so these disclaimers really matter, and I am going to walk you through it and give you a step-by-step flow chart to 2316 to figure out whether or not a seller actually disclaims these warranties. Now, in this case, they tried to disclaim this warranty. On the back of the form, it said there were no implied warranties made. What's the court say about that, and why?
They say that is not valid, because if you're going to try to disclaim the warranties, it has to be in like a different typeface or color or font size. It can't just blend in with the rest.
Right. And by the way, for those of you should have your statutory supplements, start taking a look at 2315 and 2316, because I'm about to get real directive on the code there. Then you can use mine because I know what it says. So you pull up, make sure you got 2315 and 16 under your nose. All right. So So that's what it says. That's the black letter law of the case. The black letter law of the case says, because the disclaimer of the implied warranty of fitness for a particular purpose was not conspicuous, it did not work under 2316. And we're about to read the language of 2315 and 2316 to try to capture why that's the case. All right? But to start, let's start with 2315. What are the elements, and this is starting to get a little unfair because the case actually for a 2315 case doesn't really talk about the elements of 2315 all that much. What do you need in order to bring a claim for implied warranty of fitness for a particular purpose? And remember, I'm going to say this again, every fact pattern on the bar exam, on my exam, and in your practice, every single one of them is going to involve you analyzing 2313, 2314, and 2315. And so if you think the facts we're about to talk about sound a lot like facts we've talked about before, no kidding. That's your superpower. You get to bring each of these claims based on the same set of facts. But what are the elements of a 2315 implied warranty of fitness for a particular purpose?
So it looks like the seller has to be aware of the particular purpose?
That's right. So first of all, there's two parts of that. First of all, notice that this is a particular purpose. What's the difference between an implied warranty of fitness for a particular purpose versus an implied warranty of merchantability?
Well, if I come up to you and I ask, I'm looking to buy a paperweight, you can then offer me without any qualms in your mind your 1986 Ford F-150.
Yeah, right? Like if that's your specific purpose, notice that that is not fair average quality. I'm going to make a silly example that I draw from my sales class, but I hope it'll nail it down for you. Let's say you buy a tennis racket, and the tennis racket cracks when you're playing tennis. What warranty are you going to bring a claim on? And I'm going to open this up to anybody. Yep. Merchantability, absolutely correct. Tell me why.
Because you're using the tennis racket for the exact purpose it was meant to.
Yep. It was meant fair average quality for a tennis racket. And like, can we play games with high-end pro tennis racket, complete piece of junk, low-end tennis racket? Can we play games to stretch that? Sure, but we're still talking about an average within some range. Okay. Let's say I buy a tennis racket and I ask the person, I come in, I say, look, I'm doing a comedy sketch. And what I'm going to do with this tennis racket is I really need it to strain soup. Can it do that? And he's like, oh yeah, this thing is like rated 3 years running, best soup straining tennis racket of all time. I think you should, and I'm getting ahead of us on the prongs here, but I want to give you the fact pattern. You want a soup straining racket? This one. This is the one you want. This one right here, I'm going to pick it out for you. You can rely on me. I'm giving you this one, like just knocking it over the fences for 2315, giving you all the facts that are just make it easy. You can rely on me. I will pick this out for you. I know your particular requirements. You need it to strain soup, and I am going to pick it out for you, and you're going to rely on my judgment. That is textbook 2315. Can you see that the particular purpose of straining soup is very different and doesn't get captured by the implied warranty of merchantability? Right? Can you see that by stretching and constraining the implied warranty of merchantability, you might be able to bring both causes of action on the same facts? Sure. But we're talking about something different. This is, does it have a particular purpose? Now, I'm going to make one further point about this. On my exam and on the bar exam and in your practice, where have we heard this before? And I'm going to give you the textbook way the bar will give you a 2315 claim. I'll do it again. Person walks into the store, says, this is what I need, and the store person picks it out for them. That's your fact pattern. All right? Where have we seen this before? Say a person who walked into a car dealership and said, I need a reliable car. And the guy's like, hey, this car right here, it's like a camel. Right? That is, we've seen this before under 2313 express warranties. We can bring the same cause of action, we can bring the same different cause of action on the same facts. I need you to see under 2313, what's going on there is, I said I needed a reliable car. You picking it out for me was a confirmation of a sufficiently definite fact. Therefore, that is an express warranty. I've expressly said the car is reliable. That's theory one. Theory 2 is I come in and I say, I need a car for my kids to drive. Turns out to be true. What you don't know about me is that over the past week, my kid, the oil light came on, and the Hyundai Accent that my youngest kid's been driving does not exist anymore. Fortunately, everyone's fine, but the Hyundai Accent is gone. Like, that thing is absolutely totaled. So let's say I need to find a safe car for my kid to drive, and I come in and I say, I need a safe car for my kid to drive. And the salesperson walks across and says, yeah, this one here, exactly what happened in that case, right? This one right here, that's a textbook example of 2315 implied warranty of fitness for a particular purpose. Okay. Everybody see that before we get to the next part of the case, which is about 2316. The case is supposed to show you something about how 2315 and 316 fit together. It does it, but you're not going to understand what it's saying until you look at it. If you've got your statutory supplement, get 2316 under your nose, because we're going to do it very fast, and I'm going to tell you what matters in each of the three. You're probably best advised to mark up your statutory supplement as we go. So, 2316.1. What does that say, Jewel? And by the way, they're really nice. They track. 2316.1 is about 2313. 2316.2 is about 2314 and 2315, right? Like, it's nice. It's nicely stacked up. So 2316.1, what's it say?
That is about words or conduct that create an express warranty.
Yep.
Be construed as consistent with each other when possible.
Right. So first, let's start. Words or conduct that create an express warranty. I would like a reliable car. Yeah, this car is reliable. Like, I can't make that any more an express warranty if I tried. This car is reliable. This car gets 50 miles a gallon. This car is green. I'm making statements about it, right? Okay, so then the question is, can we limit that? Can I say, this car is reliable, and I will make that warranty for 3 months? Can I do that? Yeah, I can do that. Can you see how, based on the first sentence that Jewel read? How does that 3-month limitation work with making a warranty that, yeah, it's reliable? Yeah.
Well, it's negating or limiting it to some degree.
Well, it's limiting it, but it's not negating it. Yeah, it's limiting it, but it's not negating it. And you can see how a limit would be consistent. Say, like, yeah, it's going to be reliable. I will warrant its reliability for a year. I'll warrant its reliability for 3 months. I'll warrant its reliability for 5 years. Whatever, I don't care. But all of those are perfectly consistent. But what if the language is not consistent? It's not a consistent limitation, right? But is a negation. Jewel, keep reading.
Negation or limitation is inoperative to the extent that such construction is unreasonable.
Okay, so negation is inoperative. It means your attempt to disclaim that express warranty doesn't work to the extent that you're saying, no, that promise never got made. You can't say that. You can't say, I disclaimed that promise. If you did, you can't say you didn't. It's inoperative. You can say, we made it for 3 months. You can say, we limited it to, like, you have to supply the warranty claim in writing. We can put conditions on it. That's fine. What we can't do is both say yup and nope at the same time. We can't make the promise and negate the promise. And 2316.1 is the source of why you need to be able to detect hidden 2313 claims on the bar exam and in your practice, because standard attempts at disclaiming them often don't work. And you'll just look at it and you'll be like, oh, this says there are no warranties express or implied other than those that appear on the face of this document. You'll see that language. It's going to look scary for your client. What you need to do is figure out how to walk straight through that like you're carrying a lightsaber, because you can just walk straight through it. That disclaimer is ineffective, inoperable to get rid of express warranties that you've made. All right, that's thing one. Any questions on that before we move on to 2316.2? Yeah.
So I thought if you like bought a car with an as-is integration clause, that would get those.
Yeah, we're going to get to 2316.3, but let me give you the black letter law straight off. No, as is and with all faults, do not get rid of express warranties. They do not get rid of 2313. They get rid of 2314 and 2315. They really do. But they do not get rid of 2313. And that's a really important one, because every contract ever, like go look at Google's contracts for services. First of all, what law governs Google's end user license agreement with you when you log into Google Docs? UCC or common law? Common law, like obviously common law, right? Except they're so worried about this, they have as is with all faults, like in their software agreements, because of things like Pro-CD versus Zeidenberg, which have applied the Uniform Commercial Code Article 2 to software sometimes. They're so worried about it, they're going to put these super powered words in, but what we need to understand is those do not negate an express warranty. If I make an express warranty, I can't just say I'm selling this to you as is and with all faults and have that be operative. I can say I'm selling it to you as is and with all faults, and as Fletcher pointed out, keep evidence of the making of the express warranty out of court under the parole evidence rule. But what I can't do is I can't both say yep and nope at the same time. All right? Now, go ahead. Get to
Yeah, could I say, kind of make it a reasonable limitation, like it's reasonable for a day?
You can put in a reasonable duration, but you do so at your peril. Courts kind of like consumers on the very few cases that they get through on that. I wouldn't set that. And I don't want to go off on a tangent. Yes, there are things that you can do there. The language we're looking at under 2316 is, can you take the promise you made and make it consistent with this other written limitation? And like I can see, you know, if it's an important thing, or like if it's goods you damage even by unpacking, I could see a 24-hour limited warranty. Sure, but you best write that in the document, because if a court's just like, I'm picking a reasonable number out of a hat, it will not pick 24 hours. Oop, okay. All right. Moving on to 2316.2. What's that say? And we're going to try to capture this. 2316.2 has the answer to this case in it. So we're going to look for that. And we're also going to look for another rule. What's it say?
Says subject to subsection 3 to exclude or modify the implied warranty of merchantability, or any part of it, the language must mention merchantability, and in case of a record must be conspicuous.
Okay, so let's stop with that. This is the black letter rule. Write it down, y'all. If you are trying to disclaim 2314, and every company wants to disclaim 2314, it is part of your job to help companies disclaim 2314, even though that should make you feel like less good as a person. What you do is you need to do two things. First of all, you need to say the word merchantability, either orally or in writing. You have to say, we're disclaiming the implied warranty of merchantability. You have to say it. Say merchantability. And the second thing then you have to do is, if there's a writing, and this is the big difference between 2314 and 2315, if there's a writing, that writing must be conspicuous. And I'm going to say it one more time. To disclaim the implied warranty of merchantability, one, you must say or write the word merchantability as part of your disclaimer. And two, if you write it, that writing must be conspicuous. Let's change the facts of this case. Let's say that on the back of, well, let me ask you this. Does the language on the back of the form in this case work to get rid of the implied warranty of merchantability?
The language does.
But the
Like typeface.
typeface and positioning doesn't. It's not conspicuous, says the court. Okay? The place they'll catch you on the bar exam is, note that disclaimers of the implied warranty of merchantability do not need to be in writing. Do you see that in the language that we've looked at? Because we're about to change that, because I don't know why the code drafters like giving me nightmares and giving you problems, and the bar examiners easy questions to ask. Because how do we get rid of 2315? We're now done with 2314. You'll get how to do it? Say merchantability or write merchantability, I don't care. But if you write it, it must be conspicuous. 2315, how do you get rid of it? What's that next sentence? Just moving down to 2316.2.
To exclude or modify any implied warranty of fitness, the exclusion must be by a record and conspicuous.
Okay, did you hear that? To exclude 2315, the implied warranty of fitness, it must be, one more time, Jewel?
By a record and conspicuous.
By a record and conspicuous. Does an oral limitation, does an oral disclaimer of the implied warranty of fitness work? No, it simply doesn't work, flat out. It simply does not work. Okay? See that? And if you do want to disclaim it, it must be in writing and it must be conspicuous. So the conspicuousness thing fails in both of these cases, but I need you to see that difference because that's how they're going to test it on the bar exam, right? There can be oral disclaimers of the implied warranty of merchantability. There cannot be oral disclaimers of the implied warranty of fitness. I don't know why. I mean, I probably could make it up, but we don't have time. All right? That's true. Now, we're going to get to your point in a second because we got to get to 2207.3, which blows all of this up. But this is what I'm going to call the Hogwarts section of this, right? The idea is you have to say the words exactly right in order to get the effect you want. We're going to move on from there to just doing it in common parlance, to just doing it the standard way. Everybody clear on 2316.2 before we move on to 2316.3? Fitness is, the warranty is the implied warranty of fitness for a particular purpose. And when they say implied warranty of fitness in 2316, they mean fitness for what? Fitness for this purpose. That's what an implied warranty of fitness is. It's not merchantability, it's not a fair average quality. It's fit for some task that the parties have communicated. All right, 2316.3 has a lot in it. We don't have time. Here's the deal. If you say or write as is or with all faults, that knocks out 2314 and 2315. The litigation comes from the fact that 2316.3, this is because they wanted to capture everyday salespeople's behavior. And they know what as is and with all faults means. The litigation comes from the last part of that sentence where it's not just as is or with all faults. That makes it easy. But it's as is with all faults or other language that makes it clear that there are no warranties. Well, okay. How about, what language in this case might have made it clear that there were no implied warranties, Jewel? The language that they put in there saying there weren't any implied warranties. I don't know, right? So the whole thing's a little circular and dumb. I can tell you if you look at the official comments, what they were mad about when they wrote the statute was exactly the kind of language saying we're making no implied warrant, we make no warranties express or implied. That's what they were mad about. They wanted to say, no, you need to do more about that. You need to say the word merchantability. If you want to disclaim fitness, it's got to be in writing and conspicuous, right? They wanted to say you can't just do this blanket disclaimer. But then if you look at 2207, sorry, not 2207, if you look at 2316.3, you can bring that full circle right back to words which make it clear that there are no other warranties made here. As is or with all faults are magic language because it's listed in the statute. And so that's golden. That's absolutely best top tier standard. But also you could make the argument that other language that makes it clear made it clear. And in this case, you're kind of wondering, hey, well, how about what about no implied warranties wasn't clear? Why doesn't 2207.3 work? All right. Any questions on that before we get out? What we've just done is we've done 2315 and 16, and then we've done how to, before we get to federal law, deal with the differences between disclaiming merchantability versus disclaiming fitness. Because every company wants to disclaim these, and so you need to know how to do it. Any further questions on that, Eileen?
I just want to make sure I'm understanding this right. They, 316.2 puts these magic words out and then says you have to say them. And
Yep.
then 316.3 says here's an uber magic word, and it's actually less specific. So it's just, why even include two? Like,
Yep.
What's the point?
Absolutely right. Yep.
Okay, just
Yep. I mean, there's other reasons, but we don't have the time. There's another warranty we haven't been talking about that fits into this. Join me next year.
You said, so 216.3 knocks out 2315 and 2314, is that correct?
That's correct. As is with all faults means it's as is with all faults. You're not making any representations. Okay. There are no warranties. You're not making any warranty claims. All right. Questions on that? Then we're going to move on. So let's move on past Utley to Gilbert. And Lucas, would you mind setting up Gilbert for me, please?
Sure. So, in Gilbert, we've got a individual who buys an RV in the state of Arizona, under Arizona law, the court kind of determines that they bring it back to their home in Georgia, and they go and they find that it has a ton of problems. They go in to repair it. I think it's at 7 times within like the first couple months. Some of the problems include like electrical problems. The DVD reader doesn't work. The VCR doesn't work. The cabinets are like not colored correctly, I guess.
Right.
There's a limited warranty for 1 year or 12,000 miles, whichever expires first. And basically now it's just sitting in their driveway. The plaintiff wants or files for breach of warranty, but I guess I should also note this lawsuit is between the manufacturer and the buyer, not.
That's the key case. That's the key question I was going for. Brilliant. Keep going. Yep.
Yeah. So then they file for breach of warranty, breach of written warranty, breach of implied warranty, and then they basically want to get rid of the RV and get their money back, which is the revocation part.
Yep.
Do you want me to talk about what the court says?
Yeah, let's go ahead and give the results here. We will then walk back through them in some levels, so you're just preparing the first set of answers, but go for it.
Sweet. So basically, for the breach of the written warranty, because this was a limited warranty and not a full warranty, they basically, the court finds that they didn't actually breach that because the section of the MMWA that that the plaintiff claimed they breached only applies to full warranties. For the breach of implied warranties, the defense says that they need to actually show that the problems are caused by defects in their manufacturing, and the court kind of says that that's not true. That's not Congress's intent with that specific law, and basically they rule in favor of the plaintiffs, or they deny the summary judgment of the defendant, saying that these issues minus the steering and the brake issues were or should be covered under the warranty that they had.
Under the limited warranty, yep.
Yep. And then with the revocation, they basically say that the motion for the defendant's motion for summary judgment is denied. The defendant argues that the plaintiffs should just pay the repair costs because the repair costs aren't that high in comparison to the value of the RV. But the court also says that they actually can't really have this claim against the manufacturer. They need to make it against the seller because that's kind of how revocation works in general. I think
Yeah.
That's pretty much all of it.
Okay.
So it's kind of
No, it's a lot, and it's because this is a leaky case. This case leaks all over the last half of the class. This case is mostly about stuff we will hear later on. For now, I want to bear down on a couple of key points here. One, I do think, let's get some things out of the picture before, and then narrow down to the very narrow thing. What law are we talking about here?
this is under the UCC.
It is under the UCC. Is that what the cause of action was brought as?
No, they didn't. They brought it under, they tried to bring it under Georgia law, which was just wrong. And then I don't think they even mentioned, they brought it under the MMWA.
Magnuson-Moss Warranty Act. Yeah. So y'all, this is where things start to get federally complicated. How do I do this? There is a federal statute that tries to reinforce warranties. 2316 was still too easy. People were still making warranties and disclaiming them at the same time. Most of the time, that blue border warranty you got with your product said something like, "We make no promises at all, sucks to be you." At that time, Congress was mad about that, and so passed a federal law to deal with it. This is not at all the kind of federal law you will be used to in law school. You're used to federal law under the Supremacy Clause trumping state law, and federal courts being the place where many parties with diversity jurisdiction want to bring their causes of action. That's where a lot of your case law comes from. This federal law goes the other way around. This federal law says we're going to back up state law. We're going to rely on state law, and we're going to reinforce state law, including, by the way, this is a weird one, you bring these cases in state law courts. This is a federal claim brought in a state law court. That works under the Constitution because state courts are courts of complete jurisdiction. They have jurisdiction over everything that hasn't been taken away from them by the federal government, right? So they have jurisdiction to do it, and the Congress was like, yeah, great, we're going to leave that with you. So it's sort of the opposite of bringing a state claim in federal court. Think Erie and other cases like that. This is the opposite of bringing a state claim in federal court. This is bringing a federal claim in state court that is nevertheless grounded on state law. The reason that I did that is because there is something very weird going on here. Let's dispose of the easy stuff, and then I'm going to give you a chart for the hard bit. Here's the easy stuff. What did we do with their claim then that as a matter of federal law, this contract did not have a repair or refund option, right? Because that is a part of 2304 of the Magnuson-Moss Warranty Act. It says, if you give a full warranty, part of a full warranty is that you must not just give the option to repair it, but you must give the option to replace it or get a refund if there is a violation of the promises in the contract. And that's what they want here. They want to give the damn thing back and get a refund. Why doesn't that work in this case?
So that MMWA, basically you can only get a refund or get a replacement if it's a full warranty, but they had a limited warranty, so that just didn't even apply really.
Perfect. Their first cause of action under 2304A, down the tubes. You see it? Their second cause of action, and that cause of action was just based purely on federal law. But their second cause of action, we need to address a little bit more deeply. Everybody sees the burden of proof problem. I'm not even going to ask you about it. You just see how it would be almost impossible to prove as part of your complaint that the defect came from this part rather than that part. The court says, no, it's enough to just say there was a defect. And then if the defendant wants to say, that wasn't from our part, they have the wherewithal to prove that. Everybody sees that part of the case? All right, that's much less interesting. What I need us to focus on, though, is the following, which this case is a very strange example of. That's why I liked how you set it up, that they started with Georgia law, but then they came over, right, and they were looking at Arizona law. And here's why this matters. Write the following down. Under Magnuson-Moss 2310, 2310D, Magnuson-Moss 2310D. Magnuson-Moss says you can sue under Magnuson-Moss, not as a matter of state law. You can sue under Magnuson-Moss for any violation of an express warranty or an implied warranty. That's step one. Step two is that under Magnuson-Moss 2301, 7, the implied warranties we're talking about that you can sue on as a matter of state law, those implied warranties that you can sue on, anybody want to guess what implied warranties Magnuson-Moss is talking about? 2314 and 2315. So 2301-7 says the implied warranties we're talking about are the warranties implied under state law, which are 2314 and 2315. Now there's two last steps, and then I need you to ask me about this because this is easy if you just apply it straight down. It's impossible if you don't get the steps. The third step is, under Magnuson-Moss, if you take a look at it, and I'm vastly exaggerating here, but if you take a look at 2301's definitions, and you look at who can sue who, it turns out that anyone who gets the goods in their hands can sue the maker of the warranty or the manufacturer. What does what, and I'm going to use a legal term of art, that abrogates virtual privity. That does that shift from the cozy core to the industrial economy. That says, you know, if Honda's got a 90,000 mile powertrain warranty and I buy a Honda from Lexington Honda and the powertrain breaks, who can I sue? Honda, we would think, in a modern economy, and that's what Magnuson-Moss reflects. No, you're not going to sue the Honda dealership, you're going to sue Honda on its express warranty. And this is saying, yeah, you get to do that. You can, a person who eventually gets their hands on the product can sue the manufacturer. And I need you to understand, what class are we in, ladies and gentlemen? Contracts. What contract has the end user signed with the manufacturer? I need you to see how radical this stuff is, right? None. There is not a single contract that these people have signed with each other. Do you see it? And what we're trying to do is adapt from the cozy core economy to the industrial economy to try to fix that problem, because otherwise we have this issue where the market's being flooded by stuff that's being advertised as having all these characteristics and these warranties, and it turns out none of those warranties would be enforceable. That's crazy talk. There's one last thing. So far what we've said is 2310D lets you sue on express warranties or the provisions of the Magnuson-Moss Warranty Act. Say, for example, if they had said full warranty at the top and then not given that repair or refund option, right? That would be a violation of Magnuson-Moss like itself. So under Magnuson-Moss 2310, you can sue for failure to comply with the provisions of Magnuson-Moss. By the way, if you don't have a full warranty, what do you have to say, Lucas? If you don't want to be held to have a full warranty?
Oh, you have to like expressly say it.
You have to expressly say
It's a limited.
limited warranty. That's the most important thing you can take out of that. All of your warranties must be limited. I will come to your firm, right? Do not make full warranties. Your clients will not love you for that, all right? Unless they tell you you have to. So you have to say that stuff. So you can sue for violations like that, not saying limited when you need to say limited kind of thing, right? And get sued for that. But you can also get sued for violation of implied warranties. How are implied warranties defined? As implied warranties under state law, that's 2314 and 2315. And there is a vertical privity component sometimes, that in some jurisdictions lets you directly sue the manufacturer even though your names are not on any contract together. All right? There's one last step, and this is the one that courts screw up. 2308 under the Magnuson-Moss Warranty Act says the following, and this is the big payoff of the whole thing. Go read 2308, Magnuson-Moss, but when you do, I need you to understand what it's saying. If you make a full warranty, you may not disclaim the implied warranties under 2314 and 2315, and you may not limit them in duration. I'll say it again. If you make a full warranty, you may not disclaim. You will try to disclaim, but what I'm talking about is a lawyer with a lightsaber. You're going to look at language saying, oh yeah, as is, with all faults, and you're just going to be like, just straight through the disclaimer as a matter of federal law. If you make a limited written warranty, if you make a full written warranty, you may not disclaim the implied warranties of merchantability or fitness for a particular purpose, and you may not limit them in duration. If you make, second part of this, write it down, y'all. This is just absolutely key. If you make a limited warranty, a limited written warranty, you still can't disclaim the implied warranties of merchantability and fitness for a particular purpose, but you may limit them in duration. Now, courts have such a hard time reading this. I am well aware there is case law that profoundly misunderstands this, but it is not unclear. If you read the statute, it is fairly straightforward, and many jurisdictions pull this together. All right? Sure. The big payoff is, for you as a practitioner, you will see disclaimer language. You will fire up your lightsaber and walk straight through it. Because if they made a full warranty, they cannot disclaim 2314 or 2315, and they cannot limit their duration. I'll give you a teaser question to take home. What happens if you see a 90-day full warranty? They love putting this on the bar exam. 90-day full warranty.
You can't time limit a full warranty.
I think that inherently becomes a You're, you're advertising the time limit first before you're advertising that it covers everything.
So I think you can begin to see the problems, Fletcher, yeah?
You have to conspicuously say limited in order for it to be.
One, you have to say conspicuously to say limited, but I'm asking you the question that they often put on the bar, which is about the thing that nobody does, which is the language full warranty, which at this point, you should be going, danger, Will Robinson, every time you see that crap, right? But if you make, this is the reason they do it. Here's the answer. This is the question you will get on the bar. They will say, here is a 90-day full warranty, and then the date that the parties are dealing with is in month 4. That's at 120 days. And what I need you to see is, listen to what I said, if you make a full warranty, you may not disclaim the implied warranties, and you may not limit their duration. Here's the thing, your 90-day full warranty actually does end after 90 days. That's fair enough, like that can do, you can do that. But your implied warranties of merchantability and fitness for a particular purpose just keep on going. And it does not matter if the contract says as is. And it does not matter if the contract says with all faults. And it does not matter if under 2316.2 the contract mentions merchantability and has it in glowing type font 11 miles high. It doesn't matter. If you make a full warranty, you can limit the full warranty's duration, but you may not disclaim the implied warranties, and you may not limit their duration. And that's why they put that one on the exam. And you will never see it in practice because no student of mine is going to issue a full warranty. But on the bar exam, they love this a lot. Now, then you'll see the same question done again, 90-day limited warranty, and they limit the implied warranty of merchantability and fitness for a particular purpose to 90 days. What do you do with that? Yeah, at 120 days, that works just fine. You didn't disclaim them, you just limited them in duration because it's a limited warranty. All right, I know that's a lot and it's a lot of lecturing. I needed you to see how that statute fits together or you're not gonna get the big thing. There's 2 things you need to know then about Magnuson-Moss. One is you can use it to pop a lightsaber and go clean through these disclaimers. All right. The second is Magnuson-Moss does offer consumer side attorney's fees, which is one of the only ways that people bring lawsuits about movable goods anymore, right? Think about the cost of hiring you for a weekend versus the cost of fighting about your laptop. You're just not going to do it. That's why this case is about an RV, right? It's a good, but it's really valuable. But also under Magnuson-Moss, your big pull is because you can get attorney's fees under it. So this both lets you go through these disclaimers that are in every contract. You go through them like they're not even there. And you can get attorney's fees. Yep.
So like Magnuson-Moss is basically just like a restatement drafted by the legislature.
Yeah. Or it's best understood as kind of like a backup, like a hardcore backup of the state law rules. There's one final point. I do want you to notice the most important point about the case, even though it's hidden miles deep. And that's this. If you took federal law seriously, that the person who gets their hands on the goods can sue the manufacturer, that's a law that abrogates vertical privity. But you'll notice the court doesn't go for it in Arizona. What does the court say about vertical privity in Arizona?
It says that it only applies to sellers.
That's correct. So you can't bring, I need you to see it, you can't bring a 2314 claim in Arizona. You can't bring a 2314 claim against the manufacturer. Lucas, tell me cleanly why. You can't bring in Arizona, and I can't stress to you enough how much this is different in other jurisdictions. There was a reason they wanted Georgia law. In Arizona, you can't sue a manufacturer on an implied warranty. Why?
So revocation basically puts the buyer and the seller back to where they were before the contract was made.
Yep.
But that wouldn't happen in this case. It would put the plaintiff back where they were, but not the manufacturer because they weren't the actual seller.
Because they weren't the actual seller. And to be clear, they're pushing it saying you didn't violate the implied warranty of merchantability. Why didn't Safari or Monaco, why didn't Safari, or Monarch, sorry, why didn't Safari, later Monarch, violate the implied warranty of merchantability? There was no revocation because Monarch didn't violate a term. That's why there was no revocation. They didn't breach the contract. in this sense. Why didn't they breach the implied warranty or merchantability? Because there's no privity. Because they weren't the seller. And because Arizona law says you can only sue the seller under 2314. With me? In some jurisdictions, Magnuson Moss lets you abrogate that vertical privity. In jurisdictions like Arizona, it does not. That's a current fight across the states. Find out what state you're in.
What's Virginia's position?
Virginia's position is even stranger. They have their own privity rules that are related to a different statute, 2318, that we're not going to touch on, and they have very much gone their own path. Most states, including Virginia, have a state products liability act outside of the UCC that tries to patch up this hole in law that says normally you wouldn't be able to sue the manufacturer because you never signed a contract with them. And that's just not how modern warranties work. And so most states have this Products Liability Act that does abrogate that privity. All I can tell you is go read your state's Products Liability Act and mention it on my bar. Say, look, there's a vertical privity problem on my exam. You say, there's a vertical privity problem. I need to know if the state of denial, that's the state I always use in my exams. If the state of denial has a Products Liability Act, it'll be a huge red flag if I give you the language of the state's Products Liability Act. That's exactly what I'm asking you about. Sometimes I have done that. I will do that. I'll give you the state's Products Liability Act. But you should be aware that that's what's happening is as a matter of state law, you're trying to fix this gap where people can't sue the manufacturer because their names aren't on the same contract together. All right, cool. Okay, let's move on from this. Get through this pretty cleanly. And on to modifications. Angel versus Murray. And let's see. Yeah, Benton, if you wouldn't mind setting up Angel versus Murray for me, please.
Yeah, so in this case, Murray has a contract with the city of Newport, Rhode Island. He's renewed it for 5-year terms since 1946. The latest renewal at the time of this case is 1964. Per that contract, he is responsible for removing the refuse for the city's needs, whatever that might be. When they sign their latest iteration of the contract, they kind of have an anticipation it's going to be 25 new homes per year, and they base their price on that. However, partway through this contract, there's a sudden addition of, I think it was 400 new dwelling units. And so, because of that and the additional work it's going to require, when he comes to the city in an open meeting and requests to the city council that he get $10,000 extra a year, city council votes and agrees on this, and he has to get paid an additional $20,000. So the suit is saying that that was illegally paid. The court, in addressing this, is looking at a couple of issues. So one of the things that they're dealing with, and probably the main thing, is that this seems to be a modification without consideration, since he's already responsible for removing all the refuse of the city. The court relies on what they call the pre-existing duty rule, saying that if you already have a contractual obligation to do something, that can't be considered for something else. They quote a couple of cases that are using that rule, supposedly with the purpose of preventing hold-up games. Those cases I think
Nailing it.
Interesting. So
Yeah.
they're kind of fun. But in this case, the court allows them to make that change to the contract, and says that there were unforeseen circumstances and both parties voluntarily agreed to the modification, so it's allowed.
So it's allowed. Okay. First of all, I want to point out, we've seen parts of this case, fragments of this case, all over the place before. Where have we seen this fact pattern before? The city's expanding, somebody's complaining about stuff. That's a good, thank you. Appreciate that. I worked hard on it. Who said it? Haynes versus city, right? The idea is that they're expanding the water. Here, it's the expanding the trash pickup, right? And it's got that same very weird component to it too. Who's suing? It's Fred. He's back, right? He's got no business in this case at all. What's his theory?
Well, he's just a really concerned citizen.
He's a really concerned citizen. But we just finished talking about the basic rules of contract, which is who can sue who under contract law? I know. We just finished this whole thing on privity, where you can sue Honda, even though you're not in a contract with them. I know we violated privity of contract, but the basic rule of contract is who can you sue? The parties to the contract. And this concerned citizen ain't one. This is another third-party beneficiary. And you can see it, right? If I am the beneficiary of the city's promises to pick up the trash and my trash is not getting picked up, maybe I can go be a concerned citizen about it and maybe I can get past that standard, all right? But that's what that's doing. It's just a weirdness that I want to dispose of in the case. Okay, then we know how this is going to work out. You've already said everything, and here's the reason we're going to move somewhat briskly, but it's because we've seen all of this before. So what's the holdout problem that they're trying to resolve, and what law are we under?
So this is under the UCC. Or sorry, no, under common law.
Under the common law. Wait a minute, you might say. Trash cans aren't movable? Trash is not movable? It's under the predominant purpose test. They're not selling them the garbage, right? Nobody's like, I am purchasing your garbage, right? They are even though it's movable, this is clearly a services contract, so we're under the common law. All right, fair enough. And what then is our old common law rule? Because there's an old common law rule in this case, and then there's a new common law rule. What's the old common law rule in this case?
So the old common law rule, I believe, would be the pre-existing duty.
The pre-existing duty rule, that is, if we have a deal already and then you want to change it, if you already have the duty to do that and you're just asking for more money, you don't get to just hold it up, right? So imagine I buy a computer, right? And they're like, oh, we noticed you really need a computer because law school's starting up. We're going to double the price on it. And the answer to that under the pre-existing duty rule is like, go to hell, go directly to hell, do not collect $2,000 more, right? All right, so that's the pre-existing duty rule. What old school common law rules are they using to stop this holdup problem? The holdup problem's a modern problem, right? That's a commercial law problem. The doctrine we use is what? The pre-existing duty rule relies on what basic common law doctrine to say, yeah, you don't get to consideration, right? It says there's no additional consideration. Thing is, when's the last time we saw this argument? A is modifying the contract, but B is not getting anything extra for A's modification. Where have we seen that argument before? At will employment. We saw it in Justice Resnick's dissent in Lakeland versus Columbus saying, wait a minute, these employees are having their terms and conditions of employment changed. They're not getting anything out of it. What did the court do to the pre-existing duty rule in the context of employment? Forbearance of termination. They turned that into the one more day rule. They made up some shenanigans about consideration, and they basically hand-waved it. What are they going to do in this context? They're going to do the same thing, right? What's the modern common law rule?
So I think it
under the restatement.
Restatement 89.
That's one part of it, 180. And what's it say?
Under 89DA, it says a promise modifying a duty under a contract not fully performed by either side is binding if the modification is fair and equitable in view of circumstances not anticipated by the parties in the contract.
Fair and equitable. I know that's weird to hear in a contracts class, but here we are, right? The modification was fair, and I think y'all can tell the difference, right? You can tell the difference between Lingenfelder, which is a holdup. The guy started as an architect of a brewery. He got halfway through the project. About halfway through the project, he said, hey, nice project you've got there. Would be a real shame if the architect walked away in the middle of the project. They're like, yeah, don't do that. We'll pay you more. He finished. They said, we don't owe you more. And the court was like, yeah, that was a dick move. That was not okay. So the court used consideration to police the wind under its wings. But this is another one of these cases where the wind under the court's wings is very different from the black letter law that it uses to enforce this stuff. It used consideration in that case. It's probably not going to use consideration in the modern case. What makes this case different from Lingenfelder?
There's no coercion or duress, so it's voluntary.
There's no coercion or duress, and indeed we see in the book that it can mature into coercion or duress, although I will tell you the following thing on coercion and duress. Threatening not to perform your contract is not by itself coercion or duress. Oliver Wendell Holmes, that giant of the common law, said a contract is a promise to perform or pay. And we don't make a moral distinction between them. You either perform or you pay. But saying, I'm going to breach and pay is not an improper threat by itself. It can be, see the Boeing jury instructions, but it is not a threat by itself. So we're dealing with this lever with a range. The range is fair modifications are fine without additional consideration. We saw how the UCC modified that rule in one direction. Now we're seeing how the common law modified that rule. And we're going to just deal with hold-up problems in other ways. Using the old doctrine of consideration is a clumsy way of doing it. Let's maybe manage hold-ups some other way. Any questions about Angel versus Murray? Yeah.
So the UCC does not require additional consideration, but the common law does?
The UCC really doesn't, broadly speaking. That is, but it can't, right? Like the UCC is these long-term supply contracts over 20 years. You're gonna have to be able to modify it without one, and we'll see this in Mama Rizzo's, right? Without one person kind of getting into the way of all of this, right? Okay. Yep.
Which restatement section is it?
It was 89, and then duress is 176. Thanks for asking. I really appreciate the precision. All right. Let's move on, unless there are any questions on modifications. You can see the Boeing jury instructions. That's an example where the court finally said, yeah, you didn't just breach. You strategically threatened to breach when we couldn't go and get another substitute transaction. And so you not only breached, but you really used your option to breach to put us in the worst possible position. And so we will treat that as coercion or duress under 175. All right. Let's move on then to Mama Rizzo's, and if I don't reach you today, we will. The good news is we will see each other in a very few minutes, so we will just continue on at that point. But if you wouldn't mind setting up Brookside Farms, and we will just continue until time, and then we'll maybe continue after.
Yeah, sounds fun. Two-part special.
Yep, exactly.
Cool. Mama Rizzo's likes basil a lot, even more than me, and she decided to order. I'm calling her she because in my head I just imagine it's a pound one. I think it's probably like an awesome maker. But she decided she was going to set up a requirements contract for 91,000 pounds of basil at an agreed upon rate. That contract was modified several times. Initially, the contract included stems. They wanted to modify away from stems. The supplier, Brookside Farms, wanted more money if they're going to remove the stems. Vice President said, okay, and I'll write it into the contract. He didn't, but he said he would. They later failed to meet their minimum requirement under the contract for several weeks, but then came back and said, oh, we want our basil again. And they said, okay, but you've messed up some stuff, so we have to charge you more. They agreed to that modification, didn't write it down, and then later had to agree to a higher price because they changed the market again, didn't write it down. Kind of Shoney's fact pattern, they kept paying for a while, and then they just decided to stop. You're not supposed to do that. And Brookside Farms sued for the missing money. Mama Rizzo said, we don't owe you any missing money. We've been overpaying for all these months. Nothing's in writing, so it doesn't count.
Yeah, I mean, boy, no notes. What we've done, though, is we've done a kind of a power review of a bunch of things that we've done before, up to and including why all the obsession of writings? Statute of frauds, right? We're talking about the need to have a statute of frauds writing to modify a contract. What law are we under? Contract for the sale of goods, right, over $500, we need that statute of frauds writing not just for the initial contract, but we need it for all modifications of that contract. And so that's one of the reasons why we're having this long, dark night of the soul about whether they wrote it down or not. But on the fact of modifications, this is, what kind of contract is this? It's a requirements contract. Why are requirements contracts supported without consideration under the Uniform Commercial Code? Yeah, go for it. Well, sure, because of good faith, which supplies the standard requirement of consideration, right? They're not free, as Posner says. They're not free to say zero unless they're shutting down their business, right? Which is the good faith limitation. Why, as a practical matter, the Uniform Commercial Code going to go, oh yeah, requirements contracts are great? Because they keep changing. They have to change. And so we know what the court's going to start doing in this case. The requirements contract makes the whole thing flexible in what respect?
That it's subject to the market and market changes.
Right, but what's able to change under the requirements contract?
Is it price?
Price and the amount they need monthly.
It's the amount they need, and that's the problem, right? That's exactly the problem, is that it's not just the amount they need, it's the price is given flexibility under the UCC too, but we're not giving it that full zero, nothing, whatever, whatever. How do we get flexibility under the UCC for prices? How many cases can we draw into this case that we've already seen before? How do we get to fairness around prices? Yeah.
Every time there was ever a pegged price.
Yeah, if there's a pegged price, we do that, and
I would say like custom.
custom and practice for the industry. We saw that in a number of these jet fuel cases, right? A reasonable price will be supplied. If the party has the ability to set a price under 23306, they have to do it in good faith. Remember all these rules? These are the give in the joints, the flexibility in these modern long-term industrial contracts that have to be there. So, okay, we know then what the court's going to do with this. What's the court going to do with a double bookkeeping? You mentioned Shoney's, and that was my big star question. It's like, what is this exactly like? And Shoney's,
The court is always going to make you pay for stuff you've received.
make you pay for stuff you've received, and it's got a bunch of tools for making you do that. How is the court going to solve this problem of they didn't write it down?
Yeah, so the court, and the way the court does it, and I think there's another way they could.
I want to hear both.
The way the court did it was entirely relying on modifications. And
Yes.
so they said that original contract has stuck around the entire time. Every time you promised to write it down, you should have written it down. There's no rule under the UCC that says that you have to deliver to the other side the writings. And so they should be able to rely upon you saying that
Which we've heard where before? What's the bar to enforcing this contract as modified? Yeah, perfect. Tell me why. Yeah, we're using, do you see that adaptive? We're using that BW Glass bullshit under the UCC. Remember when we added an exception to the statute of frauds? We can't enforce this contract because we don't have a writing. That's a statute of frauds problem. How do we get past the statute of frauds problem? I believed in you! And in this particular case, I believed in you to do what? To actually write it down, and you didn't. This is an example of what I called the Texas rule in class, which is all the further I can live with BW Glass, right? I get it. We don't want to do away with the need for a writing overall. But where one party says, I'll write it down, and then they don't, and you rely on them to do it, I think we can start making a BW Glass case for it. Well done. Okay, so that's where we are as our base theory. What's yours?
So I think that when Mama Rizzo stopped receiving basil for a while and Brookside didn't contest, that ended the first contract. Mama Rizzo's came back and made an oral agreement for basil at a new price. There would be no written term that said this has to be modified in writing anymore. It wouldn't be enforceable because it's a contract for sales good over $500, but they could still rely on promissory estoppel and
The rest of it.
because they had received.
Yeah, and I was going to say, and how do we get past the fact that we would need a writing, a statute of frauds?
Do stuff that doesn't require statute of frauds.
Yeah, and what would the example, what's the exception to statute of frauds that this oral contract you're positing would rely on? It's no longer, I believed in you. It's?
Detrimental reliance, quantum error, unjust enrichment.
You could do that, although that would begin to look really rough. Tell me more, well done.
Because, well, they started delivering the basil, right, so they started performing the contract parties.
Yeah, no, they've started performing the contract as with the oral terms. And if you are accepting basil and paying for basil, which they were doing, you've got part performance all over that thing. You've got just a huge gaping hole in the statute of frauds, and they could certainly have done it that way. What I need you to see is breaking up a long-term contract into a series of smaller contracts is a major lever pull. It is a major lever pull. And every one of these cases does it and is not entirely honest about why they're doing it. They're doing it to get to the result they want. These cases are not one big contract but modified. They are not a series of individual contracts, the terms of which need to be each proven separately, which is, by the way, how the court solved this last time in Shoney's, which is where the idea came from, right? Who's right? Zero, behold the field in which I grow. I don't care. I just need you to see the lever. One long contract, subject to one set of rules. Break it up, you get different arguments. That's how you win. Be aware of the lever. All right, cool. Any further thoughts on, this is another double bookkeeping case. It's a case about modification of a long-term supply contract. If I were to put it all together, I would say the Uniform Commercial Code falls all over itself to make these long-term supply contracts super flexible. Judge Cardozo was wrong in Sun Printing. The fact that we left a price term open, the fact that we let one person decide a fair market price, the fact that the other party is free to order as much or as little as they actually need, as long as they actually need that in good faith. Zero beeps given. They're just fine with it. They give you that flexibility all day long. Where one party then is taking advantage of the parole evidence rule and the statute of frauds to try to keep out of court modifications they clearly agreed to. All I want to point out is that double bookkeeping scenario, like in Shoney's, is going to be the wind under the court's wings, although it's also useful to go and look and see how this court did it through modifications of one long contract, whereas Shoney's did it by breaking them up into purchase orders that each one was a firm offer over a period of 3 months, right? Fine. What I need you to see is the court's going to rule your way based on the double bookkeeping crap. They agreed to change it, and then they tried to roll it back, and the fact that it wasn't written down was their fault, and that together is enough to send the case the way it went. Questions about that? All right, sweet. Well, we are cruising on. You know what? People need to make it across campus for this stuff. I'm going to call it here. I'll see you at 1 o'clock for us to continue.